Now, some of you have asked me to lay out my argument for standing. So this video, I'm going to tell you why I believe both Viva and Robert Barnes are wrong when it comes to the Texas case on standing. Hey, if you're new here, my name is Nate the Lawyer, and welcome to the Broady's Bunch, where you are the jury of today's content. Now, if you haven't already, don't forget to like this video, share this video, and subscribe to the channel if you like what you hear. So I was asked if I can lay out my argument on why I believe Texas didn't have standing to bring the lawsuit in Texas v. Pennsylvania to the Supreme Court, which was dismissed. Now, I'm just going to say it. As soon as I read the Texas lawsuit, and I think about 99.9% of the legal community also thought that. It was hard to find someone who thought this lawsuit would go anywhere. Viva and Robert Barnes, who believed that the state of Texas had standing. Now, obviously, they're going against the grain, and there's nothing wrong with that. I had a lot of fans who asked me to just kind of lay out the argument on why I believe both Viva and Barnes were just wrong. So here is that argument formalized. Now, I'm going to be reading off the screen, so bear with me. So I'm taking a position that the Supreme Court rightly dismissed the Texas lawsuit on the basis that the state of Texas did not have standing to bring the lawsuit, challenging Georgia law, Pennsylvania law, Michigan law, and Arizona law. Let's get into the details. First, what is standing? Well, standing has three elements: injury, causation, and redress. Now, in its most simplest forms, standing means that for a plaintiff to bring a lawsuit, they had to have suffered some injury caused by the defendant, the person they're suing, and the court has to be able to redress that injury. If you don't have those three elements satisfied, you cannot bring your case to court. If you don't have an injury, if it wasn't caused by the defendant, or if the court can't do anything about it, then you don't have standing. Now, how important is standing to law? Well, I'll say this. In every case, in every state, in every jurisdiction, in every court, for a judge to hear a case on the merits, you must have standing. There are no exceptions. You name me a famous case, and I bet there was standing. Unless the case was dismissed because there was no standing, like this one. Now, to dismiss the idea of standing as not being serious in our legal system is ridiculous. Now, I'll even go on a limb. I would say no serious lawyer would not take standing seriously. That's just a fact. It's one of those few absolutes in law that's not discretionary. It's a fundamental principle. I don't care what anybody else is telling you. So why does Texas itself lack standing? Well, here, I'm going to present to you my logic, the law and the precedent, and how I understand it. And if you disagree with that, please let me know in the comment section. Just to be clear, it doesn't matter that the majority of states, constitutional scholars, Supreme Court justices all agree with my position, right? That doesn't matter. And it doesn't matter that a minority of states disagree with my position. We're just going to kind of look at the facts and the law and help you decide which side is more reasonable. So what injury did Texas suffer? Well, Texas says other states not following the Constitution means that Texas was harmed. Simple enough. Now, it's not just alleging someone violated the Constitution. It's how they violated the Constitution. Well, Texas says that Article 2, Section 1, Clause 2, the Electors Clause, was violated. Here's the relevant part. Each state shall appoint in a manner as the legislature thereof may direct a number of electors. So simply put, the state legislatures have the authority to make the rules to choose how electors are chosen, as long as that method doesn't violate the Constitution. For instance, a poll tax or racial discrimination. So a state legislature can choose its electors in any manner it seems fit that doesn't violate the Constitution, right? Each state has that right. So at the beginning of our republic, most state legislatures chose the electors for president themselves. They didn't allow the people to vote for electors. And because of the electors clause, the state legislatures could have chosen any method to choose electors they wanted, and they chose to elect the electors themselves. So at this point, if Texas were to sue, let's say, a state like Georgia, if the legislature picked electors, then Texas wouldn't have any standing, right? Because Georgia didn't violate the Constitution, right? They pick the electors whichever way they want. Texas picks them the way they want. I don't think there's anyone credible who would say if Georgia's legislature just picked the electors that Texas would have standing, right? Viva, Barnes, they all agree with that because Texas wouldn't have been harmed. Georgia picks them the way they want. Texas picks them the way they want. As a crazy example, the Georgia state legislature could have a dog race or a horse race and allocate the electors based on who won the race. But in all these states, they decided to do something different. Instead of just having the state legislatures vote and choose electors themselves, they passed laws to allow electors to be chosen by a popular vote. So the legislature passed laws. Now, any high school student can tell you that when a state legislature or even the federal legislature passes a law, there are two other branches that are implicated. First, the executive branch, right? They execute the laws. They have to hire polling staff, right? They buy the voting machines, etc., because they have to execute the will of the legislature. They passed the law. And then you also have the judicial branch, who now has to come in and interpret what that law means in the real world. So the state legislature passes a law, and now you have these two other branches of government who have to make that law work. Now, remember, the legislature didn't have to pass a law. They could have chosen it themselves, but by passing a law, they now put this apparatus in motion. So even if we stop here again and say, well, does Texas have standing to sue Georgia if Georgia passes a law and says, we're going to hold elections this way? And again, you would say no, because the Georgia legislature chooses the manner in which they choose electors, right? Just like Texas's legislature. So Texas wouldn't have any standing to sue because they haven't been harmed. Georgia does it their way, Texas does it their way. So at this point of our analysis, I don't think anybody would say that Texas has standing to sue, right? If Georgia legislature passes a law and says this is the way we want to hold our, right? That just doesn't make sense. But the claim that Texas is making is very specific. And they're saying that the state laws that were passed by the legislature were violated by the state's executives and the state's Supreme Courts. Let me try to formalize the logic. The four states in question violated their own state law. The court's interpretation of the state law violated the law passed by the legislature. Therefore, the federal constitution was violated because the state legislature has the sole right to choose electors in the manner in which it wants. So, since state law was violated, then the legislature didn't choose a manner. Therefore, you have a violation of the Constitution. Texas only has a case if the Supreme Court has the authority to be the final say, or what is also known as the final arbiter of what state law means, and whether state law has been violated, right? Now, do you guys follow me with that? Because that's the key to this argument. See, if the state Supreme Court says all the laws were followed, then Texas doesn't have a case. But the federal Supreme Court has to have the ability to say that the Georgia Supreme Court's interpretation of Georgia state law was incorrect. The legislature didn't mean that. And if the Supreme Court has the authority to say that the Georgia Supreme Court got it wrong on Georgia law, then Texas would have standing. So the key issue here is, does the federal U.S. Supreme Court have authority to say that the state Supreme Court's interpretation of state law is wrong? And if the U.S. Supreme Court does not have that authority, then Texas does not have standing. Simple enough. And this case hinges on Texas's interpretation of Georgia law. Texas is saying Georgia violated its own law. So the key question here is, who determines when state laws are violated? What court has the final say or is the final arbiter of what state law means? So first, let me take you to the federal court's website, uscourts.com. And it says here, and it tells us exactly who has the final say in determining what state law means. Quote, state courts are the final arbiters of state laws and constitution. One sentence, clear statement, state courts are the final arbiters of state law. So that means that state Supreme Courts' determinations on what state law means, not federal law, but what state law means, are not only final, but are binding on both state and federal courts. So Texas' claim that state law in these states were violated, which court has the last word to determine if that's true? The state Supreme Court. Well, is there any other support for this proposition? Yes. See, do you know that the U.S. Supreme Court actually has a procedure that asks state courts questions about what state law means? If the Supreme Court of the United States or any federal court wants to know what state law means, they ask the state Supreme Court what is known as a certified question. There's even a rule for it. Rule 19 of the Supreme Court allows for certified questions of law to be asked to state Supreme Courts. Now, this happens when the Supreme Court or a federal appeals court needs to understand an interpretation of state law so they can make a ruling on another case. If you look in the description, there's an article about certified questions. So understand this. On matters of state law, the judgment of the state Supreme Court is considered final and binding on both state courts and federal courts. So now let's get back to the Texas lawsuit. So Texas claims that the final judgment of the state Supreme Courts on matter of state law should be overturned by the federal Supreme Court is just wrong. It's wrong on case law, it's wrong on precedent, and the federal court system themselves say that's a wrong proposition. Now, Texas wants to make the final arbiter of state law the U.S. Supreme Court. Now we know based on the law, that's not possible. The U.S. Supreme Court does not have that authority. So at the end of the day, when Texas asks the Supreme Court to overrule or reinterpret final judgments of state Supreme Courts in regards to state law, the Supreme Court has no authority to do so, and Texas then has no standing, since Texas's cause of action depends on the federal Supreme Court being the final arbiter of state law. Now think about this. In Georgia, cases were filed about the election problems. The courts in Georgia said the laws weren't violated. Cases were filed in Pennsylvania. The court said it's over. Nothing was violated. Move on. Michigan, Arizona. So those final judgments in those state courts cannot be overruled by the federal Supreme Court because those rulings were based on state law. So under Texas's theory, there could be no violation because the final arbiter of what those laws mean and whether those laws were violated or not has already concluded that they have not. And the federal Supreme Court doesn't have authority to interpret those laws. Now, this is the first reason why Texas's case ultimately fails. Now, even after the process, in some states, the state legislatures could still choose its own electors unless they restricted themselves from doing so. So they can choose their own electors. Now, remember, Rudy Giuliani was actually going around to different state houses asking the state legislatures to overturn the election results and showing what he believed was evidence to this end. Now, the state legislatures in Pennsylvania, Arizona, they all looked, even in Michigan, they all looked at it and decided there was nothing there. They heard the witnesses. They heard the evidence. And at the end of the day, they certified the election results anyway and refused to change the outcome of the process. And the legislature, who could have stopped it, who was asked to stop it, chose not to. So in the end, the legislature allowed the election results to be certified in a manner that they chose. They passed a law, they chose, and they said this is the way. And then after someone said, well, the executive, the courts, they did not follow the law, the legislature heard that evidence and then said, well, we're still going to go with this way anyway. That's the manner we get to choose. And we've chosen that manner, and we're going to go with this result. So now in comes Texas, saying essentially that these legislatures got it wrong, right? That's what they're saying. These legislators got it wrong. The laws that the legislatures passed was violated. Who is the person who determines if the legislature's laws are violated? It's the state Supreme Court. It's not the federal court. But even if the legislature says our laws were violated, by them then listening to the evidence and saying, well, we don't believe it, so we're going to certify the election as is, then how does Texas have standing to now go and say that the state legislatures were wrong? Because that's what we're saying, the state legislatures are wrong. The state legislatures are saying, well, we don't see any evidence of that, right? Giuliani was laughed out of a lot of those hearings. They didn't change their mind. They certified Joe Biden as the winner in those states. So this is why Texas' lawsuit was ultimately deemed to be a joke. It was a bad lawsuit that didn't pass the laugh test. It didn't pass the laugh test. And I'm not the only one saying it. When I first read the lawsuit, it was clear it didn't pass the laugh test. And there's a whole bunch of other lawyers, constitutional scholars, the Supreme Court, everybody who was in the know about this suit knew that it didn't pass the laugh test. This was one of the first times I was ever able to read a suit on its face and say, this suit is BS. Such a professional suit from an AG's office, too. This is a professional suit from an attorney general of the great state of Texas. And I was able to read the suit and say, it's bullshit, it's going to be dismissed without standing, and call it day one. And not only me, most constitutional scholars, most people in the know, everyone who understood what was going on knew right off the bat that this would be dismissed without merit. And it was. And it was. If anyone telling you something different, then, hey, I respectfully disagree. But simply put, this is why I think Viva and Barnes got it totally wrong. And now you know why. My name is Nate, loyal YouTuber. I'm out of here. Peace.